Today on Legalese, we are going to be discussing a stunning victory for the First Amendment and gun rights, as the Supreme Court would unanimously agree to bitch slap an anti-gun bureaucrat from New York who tried to deprive our nation's oldest civil rights organization, the NRA, of its First Amendment rights by extorting third parties into no longer doing business with the NRA. That means today, we have my Supreme Court wrap-up in the case of NRA v. Vullo. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me just remind you guys real quick, if you want to find out more about the show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I post new content, because I don't just do videos on YouTube, I post these videos to Substack as well as writing articles that are available only over there. I post to some alternative platforms. And if you want to get notifications for some or all of those things, either way, all you have to do is head on over to legaleshow.com where you can subscribe to our newsletter and decide what notifications you would like to get sent right to you. All right, we have got a lot to get to here today, so let's just jump right in, shall we? So, as I alluded to in the beginning, we have today some great news coming out of the Supreme Court. They have just released their decision on a case that we have been covering here extensively on the show as part of my annual Supreme Court Roundup, which means we've already made videos about this case discussing it when the court added it to its merits docket last fall. We also did a video covering the oral arguments about 10 weeks ago when those occurred. And so now we're going to be doing the wrap-up video where we're going to be going through the opinion of the court. And in a fantastic, unanimous opinion of the court, authored by the court's senior liberal Justice Sonia Sotomayor, the court would indeed bitch slap a petty tyrant named Maria Vullo for her efforts to deprive gun rights groups of their First Amendment rights.
Bitches out here act like they never seen a pimp before. I raise my hand, they look at it like it's a goddamn croissant. Then BAM! Feel my pimp hand.
All right, well, in Vullo v. NRA, the National Rifle Association, our nation's oldest civil rights organization, alleges that a New York official violated the group's right to freedom of speech by urging banks and insurance companies that worked with the NRA to cut ties with the group. And just as I predicted in my Supreme Court Roundup video about this case, we would ultimately see all 9 justices unanimously siding with the NRA in finding that Maria Vullo, the former superintendent of the New York Department of Financial Services, which I'll just be referring to as the DFS from here on out, violated the First Amendment by coercing DFS-regulated parties to punish and suppress the NRA's gun promotion advocacy. The decision in this case, of course, is expected by this summer, and there is, in fact, I think it's pretty decent chance here that we see the court reverse the circuit court 9-0. Now, generally, it's admittedly usually something of a point of pride for me to be able to look back at my predictions and marvel at just how correct I was. But I have to say that when it comes to this case, Stevie Wonder could have seen through Ray Charles's eyes that the government had clearly violated the NRA's First Amendment rights in this case. And everybody saw this coming, even the faithfully anti-gun corporate media. For example, I found this clip from earlier today on CBS where they are covering the announcement of this decision.
So, Jessica, Jan, I have to admit that when I read about this case, I was surprised that the Supreme Court even took it up. It seems like really clear cut that you have somebody who is working for and therefore representing a government agency taking steps to limit the expression of, another organization. So, Jessica, I want to ask you, what was the counter argument? Because I actually don't see it.
So the counter argument here is that the government could use its role and say, you know what, if you do business with the NRA, you could risk a reputational injury. And so the counter argument here is that she was just letting these regulated entities know what their potential risks would be as a result of doing business with the NRA. But I think Jan's explanation here of the court's opinion is exactly right. And let's emphasize, one, just because you see NRA as one of the parties doesn't mean you know how this case is going to come out. And two, this is classic First Amendment. One of the first things I tell my students, the government can limit speech, but it can't pick winners and losers. It can't say, I like you, I don't like you, or I like your speech, I don't like your speech. And that's exactly what was happening here.
And even the notoriously anti-gun ACLU saw that this case was such a blatant violation of the First Amendment that they offered to represent the NRA in this case, which they did. And in fact, the ACLU's David Cole was the counsel of record when this case came before the court in oral arguments. And really nobody except the most fanatical Michael Bloomberg-esque gun grabbers sided with the claim that what Maria Vullo did was protected either as government speech or that her actions were lawful enforcement actions acceptable under the state action doctrine. Now, this case featured a fantastic opinion written by the senior liberal Justice Sonia Sotomayor. And additionally, Neil Gorsuch and Justice Ketanji Brown Jackson would both write concurring opinions. However, both of their opinions are concurrences that joined the majority opinion in full, and they only wrote separately to further clarify some additional points that they felt were worth making. So let's move on to a full breakdown of the court's opinion in this case. I am going to be providing you guys with a summary of the case itself, including the facts of the case and its procedural history, before moving on to the opinion of the court and giving you a summary that covers all the key points. Essentially, condensing the 31-page opinion into a brief synopsis of about 20 minutes, I hope. Though the full opinion of the court will be linked on the show notes page for this episode, and as always, I do very much encourage everyone to take the time and go read the entire decision for yourself. And with that said, let's get into the opinion of the court. So our petitioner in the case, the National Rifle Association, would sue respondent Maria Vullo, the former superintendent of the New York Department of Financial Services, alleging that Vullo violated the First Amendment by coercing DFS-regulated parties to punish or suppress the NRA's gun promotion advocacy. Now, the Second Circuit would hold that Vullo's alleged actions constituted permissible government speech and legitimate law enforcement. And the Supreme Court would grant cert on this case to address whether the NRA's complaint actually states a First Amendment claim. The NRA initially brought suit under 42 U.S.C. Section 1983. This is a statute the viewers of the channel should be very familiar with. This is a statute that creates a civil action for deprivation of rights under color of law. And here, the NRA would bring that suit against Maria Vullo, and in return, Maria Vullo would seek a motion to dismiss on qualified immunity grounds. Now, this case initially went to the district court, where senior U.S. District Judge Thomas McAvoy allowed the NRA's lawsuit to go forward. With that, Vullo appealed that ruling to the U.S. Court of Appeals for the Second Circuit, which would reverse. The Second Circuit ruled that the NRA's allegations against Vullo did not rise to an unconstitutional threat or coercion to chill the NRA's free speech, and in any event, they added, Vullo would have been entitled to immunity because the law governing Vullo's conduct was not clear. So this case, as it came before the Supreme Court, was a challenge to the Second Circuit's dismissal of the case. And for that reason, the NRA's well-pleaded factual allegations are, in accordance with the Ashcroft v. Iqbal precedent, taken as true during this motion to dismiss stage. Justice Sotomayor's opinion goes on to provide some facts of the case, noting that DFS regulates insurance companies and financial service institutions doing business in New York and has the power to initiate investigations and civil enforcement actions, as well as to refer matters for criminal prosecution. Now, the events leading up to this case began in 2017 when the department would open an investigation into NRA-endorsed insurance programs to provide coverage for injuries caused by guns. And in the wake of that investigation, 3 insurance companies acknowledged that some of the NRA's endorsed programs did violate New York law, and they agreed to both pay fines of up to $7 million and to refrain from providing those programs to the state's residents. The NRA contracted with these DFS-regulated entities, specifically with various affiliates of Lockton Companies, Inc., also known as Lockton LLC, who would administer the insurance policies the NRA offered as a benefit to its members. This policy would be underwritten by Chubb Limited and Lloyd's of London. So in 2017, Vullo began investigating one of the so-called affinity insurance policies, a policy known as Carry Guard, on a tip passed along from a gun control advocacy group. The investigation revealed that Carry Guard insured gun owners from intentional criminal acts in violation of New York law, and that the NRA promoted Carry Guard without the required insurance producer license. Lockton and Chubb would subsequently suspend Carry Guard, and Vullo would then expand her investigation into the NRA's other affinity insurance programs. And on February 27th of 2018, Ms. Vullo met with the senior executives at Lloyd's, where she expressed her views in favor of gun control and told the Lloyd's executives that the DFS was less interested in pursuing infractions unrelated to any NRA business, so long as Lloyd's ceased providing insurance to gun groups, and especially the NRA. And so Vullo and Lloyd's struck a deal. Lloyd's would instruct its syndicates to cease underwriting firearm-related policies and would scale back its NRA-related businesses, and in exchange, DFS would focus its forthcoming affinity insurance enforcement action solely on those syndicates which served the NRA. Now, on April 19th of 2018, Vullo would issue a letter entitled Guidance on Risk Management Relating to the NRA and Similar Gun Promotion Organization, and this constitutes what is known as a guidance letter. And in this particular guidance letter, Vullo would encourage DFS-regulated entities to do the following. First, to continue evaluating and managing their risk, including reputational risks that may arise from their dealings with the NRA or similar gun promotion organizations. Second, review any relationship they have with the NRA or similar gun promotion organizations. And third, take prompt actions to manage these risks and promote public health and safety. Now, both Maria Vullo and then Governor Andrew Cuomo would also issue a joint press release echoing many of this guidance letter's statements and urging all insurance companies and banks doing business in New York to join those that have already discontinued their arrangements with the NRA. And DFS would subsequently enter into separate consent decrees with Lockton, Chubb's, and Lloyd's. in which the insurers admitted violations of New York insurance law, agreed not to provide any NRA-endorsed insurance programs, even if they were lawful, and agreed to pay multi-million-dollar fines. And with that background, let's move on to the primary holding in this case. So, the court held the NRA plausibly alleged that respondents violated the First Amendment by coercing regulated entities to terminate their business relationship with the NRA in order to punish or suppress gun promotion advocacy. At the heart of the First Amendment's free speech clause is the recognition that viewpoint discrimination is uniquely harmful to a free and democratic society. When government officials are engaging in their own expressive conduct, though the free speech clause has no application, according to Pleasant Grove City v. Summum. But when a government entity embarks on a course of action, it necessarily takes a particular viewpoint and rejects others. And thus, it does not need to maintain viewpoint neutrality when its officers and employees speak about that venture in accordance with Mattel v. Tam. But they go on to note that while a government official can share her views freely and criticize particular beliefs in the hope of persuading others, she may not use the power of her office to punish or suppress disfavored expression. And this ties back to the precedent set in Bantam Books v. Sullivan back in 1963, where the Supreme Court explored the distinction between permissible attempts to persuade and impermissible attempts to coerce. The court explained that the First Amendment prohibited government officials from relying on the threat of invoking legal sanctions or other means of coercion to achieve the suppression of disfavored speech. Ultimately, Bantam Book stands for the principle that a government official cannot directly or indirectly coerce a private party to punish or suppress disfavored speech on her behalf. However, Sotomayor goes on to note that this is exactly what the NRA's complaint alleges Vullo did. And in reaching that contrary conclusion, she wrote, "The Court of Appeals misapplied the framework outlined in the court's 1963 decision in Bantam for analyzing claims that the government has unconstitutionally coerced someone to violate someone else's First Amendment rights. Because when the NRA's complaint is read in its entirety, she reasoned, it plausibly alleges that Vullo threatened to wield her power against those refusing to aid her campaign to punish the NRA's gun promotion advocacy. And if this is true, Sotomayor concluded, that violates the First Amendment." Sotomayor goes on to say that Vullo made clear she wanted Lloyds to disassociate from all gun groups, although there was no indication that such groups had unlawful insurance policies similar to the NRA's. Vullo also told the Lloyds executives that she would focus her enforcement actions solely on the syndicates with ties to the NRA and ignore other syndicates writing similar policies. So Sotomayor writes that the message was loud and clear. Lloyds could avoid liability for unrelated infractions if it aided DFS's campaign against gun groups by terminating its business relationship with them. As the reaction from Lloyds only further confirms, Vullo's communications were reasonably understood as coercive. Other allegations concerning the guidance letters and accompanying press release, viewed in context of their issuance, further reinforce the NRA's First Amendment claim. And while the Second Circuit concluded that Vullo's alleged communications were examples of permissible government speech and legitimate enforcement action, Sotomayor's opinion was both clear and scathing in its rebuke. noting the Second Circuit could only reach this conclusion by taking the complaint's allegations in isolation and failing to draw reasonable inferences in the NRA's favor. Sotomayor would also state that Vullo's arguments to the contrary lack merit. The conceded illegality of the NRA-endorsed insurance programs does not insulate Vullo from First Amendment scrutiny under Bantam Books. Nor does her argument that her actions targeted non-expressive business relationships. This simply does not change the fact that the NRA alleges her actions were aimed at punishing or suppressing speech. Finally, Vullo claims that the NRA's position, if accepted, would stifle government speech and hamper legitimate enforcement efforts, but the court's conclusion simply reaffirms the general principle that where, as here, the complaint plausibly alleges coercive threats aimed at punishing or suppressing disfavored speech, the plaintiff states a valid First Amendment claim. And the NRA's allegations highlight the constitutional concerns with the kind of strategy that Vullo purportedly adopted. Although the NRA was not the directly regulated party here, Vullo allegedly used the power of her office to target gun promotion by going after the NRA's business partners. Sotomayor would explain that the NRA is not immune from government investigation and regulation, and she would observe that Vullo was free to criticize the NRA and to pursue the conceded violations of New York insurance law, but these are things she chose not to do. Likewise, what she could not do was use her power as the head of the Department of Financial Services to threaten enforcement actions against entities that the department regulated or to punish or suppress the NRA's gun promotion advocacy, which she says is precisely what she did. And Sotomayor said that the main takeaway from this case is that the First Amendment prohibits government officials from wielding their power selectively to punish or suppress speech directly, as alleged here, through private intermediaries. As such, the Second Circuit's ruling is vacated and the case is to be remanded. Now, the Supreme Court also indicated that when the case returned to the Court of Appeals, the lower court could consider whether Vullo was entitled to qualified immunity, which could prove to be a high bar for the NRA to surmount. Now, concerning the concurring opinions by Justice Gorsuch and Jackson, Justice Neil Gorsuch wrote a brief, separate concurring opinion in which he noted that the court's opinion had suggested that many lower courts had relied on a four-pronged multi-factor test to analyze coercion claims like the NRA's, and he says although that test might in some scenarios be useful, Gorsuch acknowledged they are merely guideposts. And the key question he would stress is whether a plaintiff has plausibly alleged conduct that, viewed in context, could reasonably be understood to convey a threat of adverse government action in order to punish or suppress the plaintiff's speech. And in her own separate concurring opinion, Justice Ketanji Brown Jackson would emphasize what she characterized as the important distinction between government coercion on the one hand and a violation of the First Amendment. And it is only once a court determines that coercion occurs, she contends, that it must then assess how that coercion actually violates the speaker's First Amendment rights. Doing so, she continued, may require the court to apply different doctrines depending on the facts of the case. For example, she says whether, as in this case, the plaintiff alleges that it was the victim of censorship or retaliation. Now, as this case will be remanded back to the Second Circuit, that means that I will be continuing to cover it here on the channel. So when there is more to be known about this case, I will be updating you guys. So that is a very good reason to subscribe to the channel, so you make sure you see that video when it comes out. And otherwise, that's really all I have for you guys here today. Thank you so much for tuning in to Legalese. Now, if you would please take a moment and do all of those things for me that help to trigger Al Gore's rhythm. If you liked the video, go ahead, hit that like button. If you disliked it, you want to be a dick about it, you can go ahead, hit the dislike button. Definitely subscribe to the channel so you always know when I have new content coming out. Whether that's, a follow-up video on this case or my other Supreme Court cases, which are going to be coming out probably pretty rapid fire here. The Supreme Court only has a couple weeks left to get out some, I think, 12 cases that I am covering as part of my roundup. So make sure you subscribe to the channel. Please leave me a comment and let me know what you thought about this video or the topic we discussed. I do love hearing your guys' thoughts on the video and to engage with you in the comment section as much as I am able. And so if you guys would do those things for me, I would be ever so grateful. And until next time, this has been Bob for Legalese, talking about NRA v. Vullo, and of course, as always, Carthago delenda est.
Motherfucker, like Freddie Mercury. Motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full of